Let's start with the basics. What actually is a compromise agreement? A compromise agreement is often used by an employer when they want to end an employee's contract. When you sign a compromise agreement, you're giving up your legal rights to pursue employment-related claims against your employer at a tribunal or in the courts. Both parties receive something as a result of entering into a compromise agreement. Your employer gets protection from you making legal claims against them for compensation. In return for giving up your legal rights, you can expect a payment from your employer that's usually larger than you would receive in your standard redundancy package. Because you're giving up your employment rights, it's important that you take legal advice. As a safeguard, a compromise agreement is not legally binding unless you've taken independent advice from a qualified person, such as a solicitor or trade union advisor. Your independent advisor has to sign the agreement to show that the advice has been given. It's common practice for your employer to pay for the full cost of your legal advice. The amount your employer is prepared to pay is usually stated in the compromise agreement. The amount varies from case to case based on the complexity of the agreement and is often suggested by your employer's solicitor. When we provide legal advice, we never exceed the amount your employer is prepared to pay. Typically, we can invoice your employer when the agreement is signed, so there are no upfront payments for you. Compromise agreements are usually lengthy documents containing a number of clauses. Your compromise agreement should contain full details of the amount your employer will pay you and the dates by which you will receive the payment. Depending on the circumstances, there may be clauses in the agreement about who you can work for in the future. You may, for example, not be allowed to work for any direct competitors for a set period of time. Or you may not be allowed to start your own firm in competition with your employer. Compromise agreements often contain clauses covering confidentiality. These may cover you not discussing your employer's company or any of their product developments. It's not uncommon for the agreement to specify that you don't discuss the details of any payments made to you. The agreement will often contain a pre-written reference agreed in advance with your employer. If your agreement does not contain a reference, then it's a good idea to ask your employer to include one. If required, we can negotiate this on your behalf. Remember, you don't have to sign a compromise agreement unless you're happy with the terms. The agreements are often open to negotiation, and we can help you with this. If you have any questions regarding compromise agreements, more information is available on our website. Or if you'd like to proceed, fill in our online callback form or call our free phone number to arrange to speak to one of our solicitors.